Hussey with Marin Corporate Risk Associates. Thank you very much for joining us this morning. We're not going to take too much of your time, but we felt that this was an important topic that all of our clients and prospects should know about. Joining me in the presentation today is Rick Marr from Davis Marr Associates. In an effort to add some value to our clients that other brokers aren't, Marin has partnered with Davis Marr exclusively to provide our clients with human resources services and any sort of consulting services that they may need throughout the year to deal with some of these issues. Rick is an expert in the New York Wage Theft Prevention Act. This is something that all employers of all sizes are going to need to be in compliance with as of February 1st of this year. And Rick has put together a nice slideshow. We're going to try and keep the presentation to about 15 to 20 minutes tops. I know everyone's busy, so we'll get you out of here quickly. Throughout the course of the presentation, if you do have questions, you'll see that there's a little box on the side of your computer you can type your questions into, and that way we'll have the questions in a queue. And once the presentation portion is done, we'll go through those questions and get them answered. If you do have any follow-up questions, you can always contact me. I'm sure everyone has my email information and my phone number. If you don't, you can always just contact Marin at 631-283-8000, and they'll direct you to us. So again, thank you for joining us. Like I said, in an effort to really add more value than just buying and placing insurance products, we're going to continue to offer these HR services and do these types of webinars throughout the year, on a lot of different topics, and I think clients will find it useful and helpful. So with that, I will introduce Rick and let him get started.
Good morning, everybody. This is Rick Marr, and thank you, Will. This is a timely presentation, and as Will said, we'll keep it relatively short. We have some very specific goals we want to achieve, and we'll go through those in a second. This is a new law that was put on the books as of April of 2011, and the date for compliance, as Will mentioned, is February 1st of this year. So folks have only a few weeks to make sure that they're in compliance with the state's shiny new toy. So with that, we'll start the presentation. The New York State Wage Theft Prevention Act. What this is about is preparing your business. And we're going to go through the purpose of the training, which is, again, to prepare your business and not necessarily debate the merits of this law and is it good and all those kinds of things. We're going to hit very quickly the Act highlights. Most people probably see notices from either their payroll company or their attorneys or accountants sharing all of the specific data points of the law. So we'll just highlight some of those things, but it's not going to be a deep dive into the law. We can talk about those separately if we need to. We're going to talk about the risks of not complying. The Act makes the risk of not complying pretty hefty. We're going to share with you the approved documentation, where to get that. We're going to talk a little bit about what you should do in the next 2 to 3 weeks if you've not made steps to comply with this law at the company level to make sure that you're protected. And then just a couple of quick case studies to, I guess, scare the pants off you and get you motivated to make sure that this is taken care of. So again, the purpose of this training is educational, and it's not to debate, whether good, honest businesses are being overregulated by the state, but rather to make sure that your business is properly protected, and protected by completing the required notices for all employees, for all private sector businesses, non-for-profits, charter, and private schools. Okay, and the date is February 1st, 2012. Just to reiterate before we truly jump in, if anyone has any questions, there's a question bar that you can ask questions, and we can see them, and I will make sure that they get addressed either at the end or as we're going through it. So the Act highlights why. When this law was signed, when this Act was signed in December of 2010 by then Governor Patterson, the quote was that they felt that New York State employers have been stealing from the employees of New York for far too long. So that's the why. So it kind of gives you the tone as to what the state is looking at and how they're going to approach this law. What the Act clarifies and expands is the Department of Labor's authority to enforce the law. As you'll see, there's some bigger fines and penalties and ways that the state, the Department of Labor can get into your business. It expands an employee's ability to bring complaints against you or against the employer. So you know, it leans very heavily toward against the employer and towards the employee of the state. It expands an employee's ability to bring private actions for violations against the employer, so civil suits, those kinds of things. It expands the definition of retaliation, and we'll touch on that in a little bit, which is a key component of this. It has always been illegal to retaliate by discharging or penalizing someone who's made a complaint, but now the expansion of the retaliation includes threats, and threats are can be sometimes subjective. It could be a perceived threat, it could be a verbal threat, so it really expands what you have to protect against. And in the past, employers can only be cited for retaliation, but now it's illegal with damages totaling up to $20,000, so we'll go through that a little bit later. So those are just the highlights. We'll share with you in a little bit later on in the presentation where to get you know, the opinions on this act so that you can get into the nitty-gritty details, but these are the high-level purposes of the act and what are the ramifications. Oh, let me see here. Okay, so again, Act highlights who must comply. It's all private sector employees are covered by this law. So you know, it could be union, it could be non-union, it could be salaried, it could be hourly. Anyone who's a private sector employee in the state of New York is covered by this law and must have the proper documentation. If you have if you're a New York-based employer but you have employees in New Jersey, those employees are not covered by this law, so you don't have to worry about providing them the documentation and maintaining that documentation. As mentioned before, all non-public entities, so all private businesses, including charter and private schools and non-for-profits. What are the basics for compliance? There's kind of there's a few buckets here. You have an annual pay notice, and we'll share with you copies of approved pay notices. A pay notice needs to be given to each employee once a year, and it has to be in the employee's primary language. And if it's not in their primary language, it has to be noted. But the state has provided notification in some various languages: Creole, Spanish, French, Russian, Polish, and it's on the website that we'll share with you the link later on. Wage statements each payroll. So each payroll period, weekly, biweekly, whatever it may be, there are very specific items that must be in a wage statement. And each of those, a pay notice, which is an annual notice, and a wage statement, if there's non-compliance, each of those has separate penalties and separate opportunities for you as a business to make a mistake and be out of compliance. Every business must keep 6 years of records. So again, adding some extra, for most folks don't keep that many years of records, so add 6 years of records. And then finally, you know, people ask, do I have to use the Department of Labor's forms, or can I use my own? So we'll talk a little bit about that later on and what some of the pitfalls might be of using the state's approved documentation versus your own documentation. Risk of not complying. So I mentioned there are pay notices and there are wage statements. So you have a pay notice, which is needs to be provided to each employee, and there are different forms for hourly and salaried employees. And I'm tongue-tied when I say hourly and salaried together. And those notices must be given to all employees annually between January 1st and February 1st, with this January and February 1st period being the first first year of full compliance, the first period of full compliance. So the risk of not providing those pay notices on February 2nd is that each employee, each separate employee can add up to a fine of $50 per week per employee, and each worker can sue for damages of up to $2,500 for not having a pay notice. The other bigger thing that, and if you read the rules and the laws of the Act, the compliance components of the Act later on, the bigger component is a potential for a wage and hour audit. And these things have been going on quite regularly lately, and I'll show you some case studies at the end of this presentation. But this wage and hour audit is, these things can be damaging in fines and fees and all kinds of stuff, lost time, etc. So we'll talk about those later on. So we view the pay notices as a hurdle that's put in place for the potential for a wage and hour audit by the Department of Labor. So the pay notices, typically these forms are LS-54 and LS-59, and we'll show you copies of each of those and where you can find them on the Department of Labor's website. This is the LS-54. You'll see that noted in the bottom left-hand corner. You'll see the term LS-54. And this is obviously the English version, and this is for an hourly person. So this document here must be provided to every hourly worker once a year, or if they start in the middle of the year, at the time they start. And it must be signed by them, and it must be maintained in your files for 6 years. Okay, so you can see that the state has provided forms. The first question people ask is, can I make my own forms? And the answer is absolutely yes. So there are differing opinions on what the form, it has to have these components, but some people may want to say our business has this little nuance. And a risk that can be run is that if you use their form and you check something off that doesn't quite fit your business, but you check it off, it could be used against you later on. So you really want to think about if you're going to use the state's form or you want to create your own forms. This is the LS-54. This is for an hourly employee. LS-59, again, this is the English version, obviously. You can see the LS-59 designated in the bottom left-hand corner. This is for a salaried person or salaried person. Again, this document is provided in 6 different languages. And I think that the thing to really think about on this document, if you're deciding are you going to use the state's document or are you going to create your own, is if you look under number 7, overtime pay rates, it can get a little confusing because people are thinking, well, these are hourly folks. I'm sorry, salaried folks. So why am I referencing time and a half in a 40-hour work week? And then the second bullet point there is it's identifying the exemption that this person is, what's making them an exempt employee, and that's optional. And where the opinion is that this could get a little dicey for an employer is if they fill this out incorrectly. They put something in that they think is reasonable, and 2 years later, all of a sudden, it comes back and it could be used against them. So this form, people are suggesting, we're suggesting that if you're going to use this form and it says optional, leave it blank unless you're 100% confident you've spoken to an HR person, you've spoken to an attorney, and you're confident in why you're using it or filling it out. So those are the 2 basic forms for pay rate, and again, these forms need to be provided to each employee once a year, no later than between for new employees at the time of hire, and then for all employees between January 1st and February 1st, and they must be maintained for 6 years. Okay, now wage statements. So this is at each pay period, the employer must provide a compliant wage statement. So this is something you certainly want to be talking to your payroll company about to make sure that you're compliant. If you're not using a payroll company, you want to make sure you go on the Department of Labor's website, consult an HR consultant, consult Marin Corporate Risk, consult some sort of attorney to make sure that you're doing it properly. So the second thing about wage statements is you see it has additional penalties, and this is $100 per week per employee. And again, the worker can sue for damages of up to $2,500. Again, the big enchilada on this is the potential for wage and hour audits or reasons for the Department of Labor to come in if you're not compliant. For those of you who request a copy of the presentation, we're going to send with the presentation a copy of the fact sheet so you can look at the specific requirements of the wage statement and make sure that you're compliant. There are various components that need to go on there, from the very basic name of the business to when the pay period is and hourly rates and all that kind of stuff. So you just want to make sure that you compare what the status is recommending and your actual wage statements, whether from a payroll provider or you're doing on your own. Okay, but again, the big thing on both of these things, the pay papers and the wage statements, is that not only is it the fines and the ability for the employee to sue, but it's also the potential for additional audits, wage and hour audits, Department of Labor visits, those sorts of things, those are the things that are going to create major problems for employers. I talked a little bit about retaliation in the beginning, and I mentioned, and this has always been true, it's illegal to discharge, penalize, or discriminate against an employee that has filed a complaint. Now, any perceived threat is considered a form of retaliation. And to add to that, even if the employee makes a claim and the employer was not in violation, however, the employee acted in making quote-unquote good faith, then any perceived form of threat, verbal, moving their desk, anything, could be perceived as retaliation. So it really expands what an employee may feel an employer is doing, and really need to be careful about that. So in the past, if you did illegally discharge or any of those sorts of things, in the past it could mean a fine of up to $10,000. Now they have added a component to that a damages payment of up to $10,000. So the fines and damages are increasing at all levels of this. And again, I encourage you to go to the fact sheet that we provide at the end of this presentation when we mail it to you, because they're more numerous to list in this short presentation. Okay? WTPA, Wage Theft Prevention Act. Again, it provides for higher penalties when an employer is found to be in violation of paying, and then here's a typo, improper wages. Sorry about that, folks. So the liquidated damages were raised from 25% of it unpaid wages, now 100%. So these things are growing in size and risk and all of that kind of stuff. So again, other penalties are described in the fact sheet, which will be attached to this presentation. If you ask for it, we'll email it to you. Okay. Approved documentation. We talked a little bit about this, the state forms versus customized. Really consider you to consult your Marin Corporate Risk team member who can help you decide which is the right way for you and your business to go. They have resources to pull on to make sure that you get the best advice possible. You have your two types of forms: your hourly, which is LS-54, you saw that earlier; salary, LS-59, you saw that earlier. All of those are provided in 6 or 7 different languages by the state. You'll have a fact sheet and a frequently asked questions. We included where all of those things are on that website there, so if you want to go and look and write that down, I'll give you a few seconds to make sure if anyone wants to write that down. It's the New York State Department of Labor website. But I will tell you, if you go on there, sometimes it gets a little confusing, and I'm filling space here so everyone can write down the website. So if you have any questions, you can go on that website, and that's the exact space where all of the forms are. So now, here's where the rubber hits the road on this law. What should I do for my company? Some people have said to us, I feel like I'm not completely prepared for this, and why? And there are varying opinions on this. But for the most part, people have sensed or felt that the state has not been as forthcoming with this or as boisterous in their announcements of this because it's designed to be a revenue generator. And those are opinions. Those are what people feel. And that's why many folks say, I've heard about it from my lawyer, but I'm not really sure what I need to do. And so that's something to really be cognizant of, and that's part of the reason for this presentation at this time. Okay. So if you feel like you're not completely prepared, please call Marin Corporate Risk, Will, and we can make sure that any questions that you have or concerns, we can make sure that they're answered. Some people have asked, do I have to give this to existing employees or is it only new employees? It's all employees. So make sure that if you have 22 employees, make sure all of them have it. Do I need to give to seasonal hires or part-time folks? Anytime someone comes back to work, whether they are a new hire, they were laid off for a season and they're coming back at the in the spring, or they're part-time, anytime someone comes back to work or comes to work for any reason, they need to have this notice and it has to be put into their files. Do I need to give a notice for each pay raise? The answer is yes. So you want to make sure that January is bonus, is pay raise time, merit pay increases. You want to make sure that they have a new form that is signed each time. People have said, well, what if an employee refuses to sign? And in the frequently asked questions that you'll look at when we send out the presentation to you, the recommendation is, note the file, note that the employees refused to sign, put it somewhere safe so that you can reasonably say you've done everything you can in your power to make sure that this person was notified and they are refusing to sign. How long should I keep the forms? I think we touched on this a little bit. 6 years. So our suggestion is to find a good, solid, safe place for these forms. Make sure that they're available. Make sure that there's succession in the person who's handling this. There's a policy and procedure in place to make sure that the next person who fills that role knows exactly where things are and can access years' worth of records at a moment's notice. Okay. Case studies of things that have happened in the past, not necessarily as a result of this new act, but similar instances of a wage and hour audit, which we think people not in compliance with this new act will generate or trigger wage and hour audits. So recently there was a case study of a targeted industry. Some of you may have heard of this, but 46 Long Island restaurants were chosen. 35 of the 46 were out of compliance, which is pretty amazing if you think about it. 75% of businesses were out of compliance even before the increased standards of this act. So there was $2.3 million in back wages for 578 employees. And this does not include fines, back taxes, legal fees, and all that kind of stuff. So the damage was considerably higher. So when we start to look at this and look at this act, we say, not only is it the fines within the act itself, but non-compliance will generate additional problems for businesses that are going to be well in advance of the fines of the act. Okay. Second case study. This was actually one that we were a part of. This is what I call a truck and technician company. So basically they had, it was a repair service type of company that had workers that left the yard every day with a truck. went out, serviced the product, and came back. Department of Labor agents walked in unannounced due to an anonymous complaint. There were 35 employees. The agent basically told the business owner, walked in unannounced and said, I would like all the pay records for the past 3 years, and now the employer is scrambling to find them. Finally is able to find them. The Department of Labor interviews several employees off-site, and the finding is that the employer is out of compliance, owes more than $200,000 in back wages, taxes, fines, and fees. So as you can see, for a 35-person company, although the company was very successful, typically people don't budget $200,000 in their lines to handle an anonymous visit or an unannounced visit from the Department of Labor. So these two case studies were things that happened in the past 6 months and were even prior to the increased standards of the new act. So we're expecting these kinds of things to happen significantly more, and that's why we're urging everybody. Please get in compliance. If you need help, call Marin Corporate Risk. We'll make sure that you get the answers that you need and guidance that is going to protect the business. And then, finally, here's the contact information. Again, most of you have Will's contact information, but here's some additional information, and that's the presentation. So just so you you can go back and look at this. A recorded version of the webinar will also be posted on a Marin corporate website, and you can go in and look in the relatively near future. I would say that will be posted in the next day or two, so you can go back and look. But if you have any questions in the meantime, please call. If you have any questions now, type them in. I'll be happy to answer them.
Great, Rick. Thanks a lot for the presentation. I guess we'll give just a couple seconds for anyone to type in questions if they have them. While we're waiting for that, I know we didn't have the video portion of the webinar up and running today, so all of our participants can't see Rick, but if you haven't met him before, he looks like Mr. Clean. He's a little intimidating, but I would say that don't let that scare you. He is very approachable, and he is a great resource. So for any clients, that have questions or concerns about this particular act or any other human resources related issues that are outside the kind of sphere of, insurance, whether it's employee benefits or workers' comp or anything like that, Davis Marr is partnered exclusively with Marin. So, we just felt that as the Department of Labor gets more intrusive into small and mid-sized businesses, we wanted to make these human resources, consulting services available to our clients so that you guys can, first off, protect yourselves, and then also, make sure you're in compliance with all the forms and regulations that need to be completed. Rick, do you have any questions coming in?
No, I think we're good. We'll give it 30 more seconds in case anyone has one.
Okay.
And
I'll just make some closing comments. As I think a lot of our clients are aware, Marin tries to take more of a comprehensive approach to the aspect of risk. It's more than just purchasing and placing insurance products. As you'll see from this webinar and some of the ones we're going to do in the future, I think the next one we're going to focus on is cyber liability. These are topics that you hear about, they're buzzwords, but you don't necessarily know what it means to you and what's your actual responsibility as a business owner to protect your employees' information, your clients' information, and even some of your business partners' information. So, again, thank you everyone for joining us. Rick, if you don't have any questions.
Well, we have one question here, and I'm reading it quickly here. Give out annual contracts for every March for the following school year, which runs July through June. So the answer is, so the question is, do you have to provide an LS-54 and LS-59 even though there's a contract? And the answer is yes. You want to make it a separate document, but hand it out with the contract. So when you provide the contract, a separate form should be in that, or as an addendum to that, or part of that contract package that is either an LS-54 for hourly employees or an LS-59 for salary employees. Okay, I think we have another question here. Yeah, okay, so the question is, what if there are multiple ways to pay employees or multiple rates of pay for employees? This is a great question, as it goes to the complexity of this act. Although seemingly on the surface pretty simple to comply with, you need to provide a detailed explanation with the LS-54, LS-59, all the different ways that the employee is paid and all the different rates for the various jobs. So what the Department of Labor recommends is that you give the form, the LS-54, LS-59, and you add a page to it that explains everything in detail. So again, this is an area where if it's not written properly, it could create problems. But the answer to the question is yes, you must notify people of all the different pay rates they have for various reasons. Okay. All right, it looks like we do not have any other questions. So, Will, I'm done. Thank you very much, everybody.
Great, thanks, Rick. I really appreciate your time and your expertise. Thank you, everyone, for joining us. Have a great day, and don't hesitate to contact us if you have any questions or need any help. Thanks a lot. Take care.